Welcome to our Virtual Law Legal Analysis series. In today's episode, we will discuss the case of Lyceum of the Philippines Incorporated versus Court of Appeals, G.R. number 101,897. This landmark case was decided by the Supreme Court of the Philippines on March 5, 1993. Let's dive right into it. Facts. Lyceum of the Philippines Incorporated, LPII, is a non-stock, non-profit corporation that has been operating as an educational institution since 1911. In 1982, Western Pangasinan Lyceum Incorporated, LPII, was incorporated and used the word Lyceum as part of its corporate name. LPII filed a complaint with the Securities and Exchange Commission, SEC, against LPII, seeking to enjoin the latter from using the word Lyceum in its corporate name. The SEC dismissed the complaint, finding that the word Lyceum is a generic term that cannot be exclusively appropriated by LPII. LPII appealed the SEC decision to the Court of Appeals, CA, which affirmed the decision of the SEC. Issue: whether LPII has a legally enforceable exclusive right to use the word Lyceum in its corporate name. Ruling: no doubt the Supreme Court held that LPII does not have a legally enforceable exclusive right to use the word Lyceum in its corporate name. The court found that the word Lyceum is a generic term that is commonly used to refer to an educational institution. The court also found that the word Lyceum has not acquired a secondary meaning in favor of LPII, such that it would be recognized by the public as a unique identifier of LPII's goods or services. The court held that, in order to determine whether a given corporate name is identical or confusingly or deceptively similar with another entity's corporate name, it is not enough to ascertain the presence of Lyceum or Lyceo in both names. The court held that the corporate names must be evaluated in their entirety to determine whether they are confusingly or deceptively similar to another corporate entity's name. In the case of LPII and LPII, the court found that their corporate names are not confusingly or deceptively similar. The court found that the two names are sufficiently distinguishable, as LPII's corporate name includes the words Western Pangasinan. The court also found that LPII's corporate name is not likely to cause confusion among the public, as the two institutions are located in different provinces. Significance: the case of Lyceum of the Philippines Incorporated v. Court of Appeals is significant because it clarifies the law on the use of generic terms in corporate names. The court held that a generic term cannot be exclusively appropriated by one entity, even if it has been using the term for a long time. This is because generic terms are commonly used to refer to a class of goods or services, and their use by other entities does not create a likelihood of confusion among the public. The case also clarifies the test for determining whether two corporate names are confusingly or deceptively similar. The court held that the corporate names must be evaluated in their entirety to determine whether they are likely to cause confusion among the public. This means that the mere presence of a common term in two corporate names is not enough to establish confusion. The court will also consider other factors, such as the location of the entities, the similarity of their goods or services, and the likelihood of the public to be confused. That's all for this episode. What do you think about the topic? Feel free to comment and suggest what topic you want us to discuss on the next video. Stay tuned for more legal insights in our future episode. Remember, understanding the law helps us comprehend the intricacies of our legal system. See you next time. Like and subscribe.